Okay? Welcome to tonight's meeting of the Zoning Board of Adjustment of the Township of Union, which is being held pursuant to the Open Public Meeting Law C-231, Laws of New Jersey, dated 1975. Notice of this meeting was advertised in the local source, the newspaper of record, and notice has been posted on the bulletin board in the municipal building adjacent to the municipal clerk's office. Roll call.
Mr. Wiley is absent. Ms. Martins?
Here.
Mr. Bentavegin is absent. Ms. Scott is absent. Mr. Johnson is absent. Mr. McNeil?
Present.
Mr. Graves?
Present.
Ms. Ricketts?
Here.
Mr. Champy?
Here. There being a quorum present, this meeting is now declared open. At this time, I'll entertain a motion for the approval of the minutes from April the 9th.
Mr. Chairman, I move that the meeting minutes of April 9th be approved as amended and dispensed with their reading.
Can I have a second?
Second.
Mr. Chairman, let it be known for the record I was absent on that day.
Thank you. All in favor?
Aye.
Opposed? So moved. Are there any communications, Mr. Mangusa?
There are no communications at this time, Mr. Chairman.
Hearing none, our first order of business this evening will be the adoption of a resolution for calendar number 3450, Liberty Assets LLC, located at 306 Carnegie Place, Block 5811, Lot 39. Applicant wishes to subdivide and build a one-family and two-family dwelling on the lot. Board members, you've all had a chance to read the resolution. At this time, are there any board members that would like to comment, make changes or modifications to this resolution as it has been written? Hearing none, may I have a motion and a second?
Mr. Chairman, I move that this board adopt the resolution as read and modified as accurately memorializing the previous findings of this board.
Second.
Roll call.
Ms. Martins?
Yes.
Mr. McNeil?
Yes.
Mr. Graves?
Yes.
Ms. Ricketts?
Yes.
And Mr. Champy?
Yes. Proceeding with tonight's meeting, our next order of business is calendar number 3447, Liberty Assets LLC, located at 1044 Woodland Avenue, Block 309, Lot 11. Applicant wishes to subdivide and construct 4 new single-family dwellings.
Mr. Chairman, Rob Pansul, I'm the board attorney. I know the public is here tonight. You're probably here for this application. There is a letter that came in. It was circulated to the board. It's on file. The applicant is going to adjourn tonight's meeting, but renotice, because they're going to change the plan. It's going to be a different plan that's going to be proposed, which will require a new notice. The date that we're contemplating right now is May 28th. You may want to note that for your own edification, but just realize that they're going to renotice. Anyone who lives within 200 feet of the property will get an individualized notice explaining what the new plan is going to look like. We don't have it officially yet. We have an idea that it's going to be different, so I can't really say anything more than that, other than to recommend, for the public's benefit, stay in touch with our building department to file when it is. It has to be here at least 10 days before the ultimate hearing date, assuming, for example, if it's May 28th, anytime after May 18th, it'll be on file for review and be available for anybody to look at. But it will be changed. It will be different than what's here for tonight, right? Mr. Mangusa, you don't have any additional information at this time?
No, it'll come certified, so if you see a sticker on the door, it's probably that's what it's probably about.
So for tonight's purposes, I think what the board will do, just to make a record, the applicant sent the letter in. It's dated April 7th. If the public did ever want to see it, it is on file. It's from the attorney who was here representing the applicant, and it requests the adjournment for the reasons that I just stated. They have waived any constraints that were on the board to move within a certain time under the municipal land use law. That's legalese, so they protected the town in that regard. But nothing will happen until we get the new plans, public gets notice, our engineers will look at them again. It's going to be totally new. And we'll deal with the issues from there. We're really not having a public hearing tonight. I'll answer any questions you might have after the meeting, if you don't mind.
So if you're noticing people within
200 feet within the property, just whoever got notices this last time. Yeah.
why can't you notice the people within 200 feet that something
Because all the town can do is make the applicant do what the municipal land use law requires, and the state sets up those rules. It's not unreasonable. What I can suggest is maybe reach out a couple days before the meeting to the zoning board. We got information about the adjournment, and I know some people had reached out, and Mr. Manguso did represent to them that the case was going to be adjourned. I appreciate the hardship, but we don't have control over that.
No, that's not correct.
Well, like I said,
Because this gentleman reached out yesterday, saw the plans, and was not told that it was adjourned.
all I can say is we can't make the applicant renotice or notice that they're going to adjourn.
Well, why can't this happen?
I don't know who they spoke to on the town line.
They spoke to me. They spoke to me, and that gentleman, his name is Brian, right there, I told him that this was going to be adjourned. Did I not?
I didn't say that, I just knew that it would not go through tonight, is what I did.
All right, well, that's, I apologize. Certainly, if we could think of doing something to not inconvenience the public, we would. All I could suggest as the lawyer who's been doing this for 30 years is to stay in touch with the building department as he did. If there was a miscommunication or a misunderstanding, that's unfortunate. You can call me at my office. My information's on the website. If you want to reach out to me, I'll try to speak with you any way I can, because I don't vote. I'm just a lawyer.
For 30 years, I know that.
Yeah.
I'm saying a little bit of effort on the town's part, but not that many people.
Well, I mean, that's- I understand what you're saying, but that's not entirely fair to expect the town to be able to reach everybody within 200 feet to let them know there's an adjournment. It's just not feasible, Maybe we'll get to the point with the website and the telecommunications being what it is, where it could be posted. I mean, that's something that we can certainly, the municipal land use law is contemplating changing these kind of things, because they're required to also notice in the newspaper. And the newspaper, the Star Ledger, doesn't exist anymore either. So, I mean, they're changing the way notices are going to go out. So ultimately, I think what's going to happen is you're going to see notice requirements be posted on the website. I guess that's good. I mean, I'm an old school kind of guy. I don't like the sound of that. My grandparents wouldn't have been able to check that, but that's where we're heading. The website is there. Somebody's got to punch it in and check for you. Hopefully that'll happen someday, because I can appreciate what you're saying. I mean, it's 7:30 at night. It's a weeknight. People work. People got to work tomorrow. It's a holiday week, etc. That's why I'm trying to give you as much information as I can. May 28th is the contemplated date. It's not the actual date. It won't be actual until you get that notice and the publication in the newspaper, to the extent anybody even looks at the newspaper anymore for their publication. So, but certainly, Mr. Manguso's office or my office as the lawyer, you can't talk to the board members, but Anthony's the zoning officer and I'm the attorney, so you certainly could reach out to either one of us. Both as to procedures and any questions you might have about what's going to happen and when you can see the plans, etc. So I think for tonight, we need just a motion and a second to adjourn this matter, subject to renotice from the applicant. It will not be heard under the original plan it was submitted. So, I mean, that's at least, that is productive in and of itself tonight, because the plan that we vetted to some degree with the engineer in the town, the comments that we got from some of the public, I know we have them, we were ready to address it with the applicant, people who submitted information to us. That plan is not before us anymore, so, I mean, that's something at least, so you can at least take solace in that, I would hope. And I would also hope, last thing I'll say, is so we can start our Easter holiday week, reach out to the applicant who is your neighbor, one way or the other, if you can, or if you know him, or if you reach out to his lawyer. Try it. I say that all the time. He's going to be a neighbor. He's looking to build something. Maybe you have an idea. I mean, I saw some good ideas and stuff that was sent to me, which I'll communicate with the applicant. It doesn't hurt to vet your comments with who will be ultimately your future neighbor someday. May not amount to anything, but it doesn't hurt to try.
Can you just clarify that, the person who's the applicant is?
The Liberty Assets LLC is the applicant, but there is a representative that if you can't reach him, you certainly can reach his lawyer who was here, the Gassion Pamaco law firm. They represent him. You can reach them in West Orange is where they're located. If you have a question about, when I do applicant work as a lawyer in land use circles, I love hearing from people before the night of the hearing. Because we had a case a week ago where the public was here and misunderstood what they were proposing to do, read the plan, had a conversation, said, oh, I'm fine with it, and then they left. But, you know, it doesn't always happen, but it can. That's the only reason I'm suggesting that, so. I
Thank you,
think you're
Mr.
good, Mr. Chairman, and certainly, as I said, don't hesitate to reach out to me as the board attorney. I can try to help, or speak to anybody after the meeting. If you have procedural questions, I certainly can try to help you.
Thank you, Mr. Piansula. Can I have a motion and a second to adjourn calendar number 3447, Liberty Assets LLC?
Mr. Chairman, I move that we adjourn calendar number 3477, Liberty Assets LLC, 1044 Woodland Avenue, Block 309, Lot 11, to May 28th with renotice.
Second.
Roll call.
Ms. Martins,
Yes.
Mr. McNeil,
Yes.
Mr. Graves. Yes. Ms. Ricketts,
Yes.
Mr. Champion.
Yes.
Mr. Chairman, there being no further business coming before the board, I move that we adjourn.
Second.
All in favor?
Aye.
Opposed? So moved.